All right, thank you, Chris. Next up will be Maurice Thompson, Executive Director, 1851 Center for Constitutional Law. He'll be discussing the effects of the amendment and the process for getting it on the ballot.
I know most of you from the healthcare issue, if not elsewhere, so you know that my job is to be the dry guy and to go over the language, the nuts and bolts, and to put most of you to sleep and cause your eyes to glaze over as I go through the language and what it does. But the interesting thing here, as opposed to healthcare, is that this language is actually very straightforward. There's not nearly as many salacious legal issues, so it would really only take me a few minutes to go through what the Ohio Workplace Freedom Amendment says, what it does, and then what it means. Briefly, I think that Chris articulated the motivations behind the effort. Of course, this is a coalition, and we all have somewhat unique motivations. For the 1851 Center, we have an interest in improving the business climate and the employment climate in Ohio, raising Ohioans' incomes when we can, keeping Ohioans in the state. I personally don't like the fact that most people my age, in order to find employment, have had to leave Ohio and will be coming back to Ohio for Thanksgiving on planes rather than people leaving Ohio to go see their families in other states for Thanksgiving. So there are often moral components to these economic conditions, and that's one of the things that we cared a great deal about in fighting the Ohio estate tax and gaining repeal there. And the motivations really here are much the same as our work on the estate tax earlier on this year. In addition, I'd add that we do believe there is a moral component to this in that individuals should be free to form their own political associations in the workplace and elsewhere. They shouldn't be compelled to enter into any particular association just because they wish to be a teacher, a baker, a mechanic, or a firefighter in Ohio. That shouldn't mean that they have to pay a fee over to an organization whose views they may not agree with, or instead pay some sort of a fine in lieu of that fee, which is the current situation in Ohio. Now, federal law gives the states the abilities to change that condition. I should say that federal labor-related regulations are fairly specific and extremely broad, but there's no ambiguity that Ohioans have the right to change the forced unionism climate. And so this is one thing that states can do. If you have the press packet or either of the packets that are within the back table there?
Yeah, inside.
There are packets over there. They have the language in them and also frequently asked questions, so you'll find many answers to questions you may have in there. You'll also find the text of the amendment and the summary of the amendment. And like I say, as opposed to healthcare, this is pretty straightforward. This is pretty easy to understand. This would add this 22nd section to Ohio's Bill of Rights. We added the 21st section on Tuesday, which is the Healthcare Freedom Amendment, so this would be right after that, if indeed it's enacted. The amendment, so the Article 1, Section 22, states no law, rule, agreement, or arrangement shall require, directly or indirectly, any person or employer to become or remain a member of a labor organization. And Section B is the other substantive section of the amendment. States no law, rule, agreement, or arrangement shall require, directly or indirectly, as a condition of employment, any person or employer to pay or transfer any dues, fees, assessments, other charges of any kind, or anything else of value to a labor organization or also to a third party in lieu of a labor organization. So these are the two sections that really dictate the effects that this will have. The primary effect, as most of you probably understand, is that a laborer wouldn't be required to pay fair share fees over to a union simply because of where they work. It doesn't affect the way that we've drafted it, any kind of union-sponsored pension plans or anything else. It's really pretty straightforward in terms of simply allowing Ohioans not to be forced to be a member of a labor organization or to pay certain kinds of fees to a labor organization. Section 22C makes it clear that Ohioans can still voluntarily become members of labor organizations. Nothing in this section should prevent any person from voluntarily belonging to or voluntarily providing support to a labor organization. And then also, pre-existing contracts are grandfathered in. So if there's a workplace agreement that has this compulsion, we grandfather it in so that we're not tearing up existing contracts. We do believe in the sanctity of the freedom to contract and the obligation of contracts clause, and so we didn't want to intervene in pre-existing agreements. So this is more long-term effect than from day one upon enactment. Section 22D, no other provision of the Ohio Constitution shall impair or limit the rights contained herein, is necessary because of Article 2, Section 34 of the Ohio Constitution, and some of the other sections that allow for other kinds of regulations of the workplace in Ohio. So you're going to see that provision more and more when authors try to propose constitutional amendments, particularly on economic issues. Section 22E, you will want to pay some attention to that because that answers a lot of questions about what about federal law, federal labor relations law, National Labor Relations Act, etc. And we certainly can't trump federal law on this issue, and we're not trying to trump federal law on this issue. So this is a savings clause, basically says if there's a conflict with federal law, this amendment is fully effective to the extent that it's not trumped by federal law, but not effective beyond that, and can be severed if there is a problem there. But this language mirrors what's been done in many other states, so we don't expect to have a problem with that. Section 22F simply allows individuals to bring an action if they've had a problem with a violation of this section. So basically that's what the amendment does. Like I said, what it isn't union busting, it's not trampling on existing contracts or doing anything to stop individuals from entering unions in Ohio. Some of the economic effects that are worth highlighting. First off, we know the situation here in Ohio. We're hovering around 9 to 10% unemployment at any given time, which is significantly higher than the unemployment rate in states that are not forced union states, and it's always been that way. Incomes of residents in states that are not forced union states also tend to be higher. I think the two most recent examples are really telling. After Idaho passed its Right to Work Amendment in 1986, it spent several decades leading the nation in job growth and job creation. And the Federal Reserve Bank of St. Louis studied that case and found that the growth in number of businesses and establishments was about 7 times larger than its neighbors that were not right-to-work states. And this was directly because of right to work. Oklahoma in 2001 also passed an amendment similar to this, and also has exceeded national standards in terms of income growth rates. In fact, there was a recession, 2001, 2002. Oklahoma did better than any other state in those years just after passing this amendment. So we've got some important anecdotal evidence that shows that this is effective in improving the business climate, which is really helpful for all Ohioans. Briefly, other considerations. Right to work, workplace freedom does not really cause employees' wages to fall at all. It's a common misconception, but most studies show that there's a slight increase in wages in states that are not forced union, and also cost of goods and services tend to be a little bit lower because of that. There are, of course, some political factors that are worth considering. One is that their unions obviously are powerful political machines, and one of the reasons for that is that they have the ability to reach into the pocket of each of their workers through dues or through fair share fees, and then to use these funds for political purposes. So to the extent that people choose to opt out, this may impact their bottom line and any kind of distortionary effect that they've had on politics, to the extent that people do wish to opt out of the unions. 22 states currently have these kinds of laws, so if you're curious about that, Ohio will become the 23rd state to have to be a non-forced union state. And one of the things that we heard with the estate tax repeal over and over again was, well, many of these states, and it's not quite as clear, it wasn't quite as clear with the estate tax as it is with right to work, but most right to work states are in the West and in the South. Most Midwestern states are not right-to-work states. Ohio would be the first. And if you look at these states, you may say, well, people just like the warmer weather. They like to move west or south because of the warmer weather. But several economists have studied the economic conditions along counties on both sides of the border in the entire country. So every county that's on the border of a state that is a right to work versus a non-right to work state has been studied, and they found that conditions are significantly better in those states that don't implement forced unionism. So there's a lot of evidence to support that it's not the warmer weather that's driving people west and south, or at least not the warmer weather alone, but that the business environment and the amount of jobs really does matter. And for us, you know, that allows families to stay together. It allows people to not have to graduate from Ohio colleges and run off to Arizona or wherever else in search of work, but to stay right here in Ohio. As far as what arguments we expect our opponents to make, it's interesting. Healthcare did not have a lot of organized opposition. Obviously, we'll have some more organized opposition for this. In Oklahoma, the president of the AFL-CIO argued that we will not allow our wages to be cut along with less health care for our families. But Oklahoma wages increased by 3.7% a year after forced unionism ended, and the number of people covered by private health insurance also dramatically increased there. There's also an argument about free riders that is sometimes made. I think you can expect to hear that allegory, but the fact is that unions are not required to represent people that wish to opt out. If they wish to enter a workplace and be the exclusive bargaining representative for the entire workplace, then that's a different issue, but they're not required to do that in the first place. Now, the end of the nuts and bolts section, how do we amend the Constitution? I think we're all becoming increasingly familiar with this because we see more and more ballot issues these days. We submitted signatures today to the Ohio Attorney General. They have 10 days to approve our summary. Once they do that, they forward the summary and the language to the ballot board, who then also has 10 days to hold a hearing where they will determine whether this is more than one issue or just one issue. Some of you may remember with healthcare, we ran into some trouble with that, had to have a lawsuit. So there's pretty clear law on what the ballot board is required to do now, at least, and we're fairly confident this is a single subject, so we don't have any trouble there. So 10 days of the Attorney General, presumably 10 days before ballot board approval. At that point, proponents will be free to circulate and gather signatures, and they have until, I think the date is July 5th, but it's the first week of July, to submit 386,000 signatures in order to place it on the November ballot. Or if they wish to continue longer, they could place it also on the 2013 ballot instead of 2012 if either they don't get enough signatures or if they simply choose to hold the measure for one reason or another. So those are the basics of how the constitutional amendment works. And with that, I'd be happy to answer any of those nuts and bolts questions.
Let's wait for questions to the end. Let's have Barney go first.
Right.